Okay, the last topic we'll talk about in this lecture, the copyright status of video game characters. So to think about this, we need to do a little bit of background on copyright in characters. Now, we've talked broadly throughout this module about copyright in general, and remember that copyright protects original expression. Copyright doesn't protect ideas. There's an originality requirement. That's not a novelty requirement like patents, but it means you have to have yourself, the claimed owner of the copyright, yourself have come up with this expression, and it has to have, some degree of creativity and originality, a minimal degree. And one of the places that this can be a tension is, well, are you doing something that you have some degree of creativity in, or are you just taking things out of the public domain? So if I wrote a poem and the first line is half a league, half a league, half a league onward, into the valley of death rode the 800. Well, I can't claim copyright in those lines because those are famous lines. It's not because they're famous, but they're lines from the Charge of the Light Brigade, which is I think 19th century poem, right? It's an older 18th century, I'm not sure exactly when, but an older poem. Right, so if you're taking something out of the public domain and just copying it, or close to copying it, right, you may not have copyright protection. And that's the problem we have with characters, because we don't want copyright to take the stock of potential literary characters out of circulation. So think about these two characters, star-crossed young lovers from different families. The families are separated by political, cultural, or religious tension. Despite that tension, these star-crossed young lovers meet, and they fall in love, and one of two things happens. Either they wonderfully unite these families and overcome their differences, or tragedy ensues and they end up dying, right? Romeo and Juliet, other kinds of stories like that. You can't take that general description of the character out of literature. That's not what copyright's designed to do. But if the character becomes more specific, and one of the tests courts use is if the character is sufficiently delineated. Another test some courts use is the character really the heart of the story being told? A classic example in copyright jurisprudence is Superman. Superman, now of course, some kind of hero with powers of great strength goes way back to, Greek myth and Hercules and so on. But that particular character, having come from the planet Krypton, wearing the particular kind of costume that he wears, doing some of the particular things he does, that's one that, and it's recognizable, it's kind of iconic, right? That kind of thing might be protectable as a character. Well, you can see how this can get really difficult. So let me show you a few iconic characters in recent film and literature. Here's one of my favorites, Gandalf, right, from The Lord of the Rings and The Hobbit. So this, wizard character, he's got the gray beard, he's got the staff. Well, we can compare that to Dumbledore, another one of my favorite characters from Harry Potter. Now, Dumbledore doesn't have a staff, but he does have a wand, right? And the staff and the wand are in many ways similar. They're kind of the locus of the way the wizard channels his power. They're both wizards. They're both sort of high up in their wizarding order. They both have the long gray hair. They both have the long gray beard. They both have sort of constant expressions of knowing, wisdom, right? Those sorts of things. There's a lot of similarities between these characters. Are either of them protectable? Well, are there other characters that they're derived from? Well, here's one. How about this one? The long white beard, the hat, the staff. What is this character? This is Odin the Wanderer. This is from an engraving from the late 19th century, but Odin the Wanderer is a character that goes way back in various kinds of literature. And in fact, Odin the Wanderer is a literary character that Tolkien used to create Gandalf. So, are there elements of Gandalf that make him sufficiently delineated to be protectable in some way? Are there elements of Dumbledore that make him sufficiently delineated to be protected in some way by copyright? Maybe, but there are certainly elements that are not. I mean, you could do a movie or a story of a wandering wizard with a white beard and a staff or a wand wearing a robe, and that couldn't possibly violate copyright in itself in Dumbledore or Gandalf. All right, so that's general frame of the issue. Here's what happens in this Blizzard Entertainment versus Lilith Games case. Again, notice Northern District of California. What you have is just an opinion on a motion to dismiss. Blizzard claims copyright in its World of Warcraft characters, the same game we looked at just a moment ago, and the defendant allegedly copies some of those characters in games for mobile devices. So I gave you the complaint and the answer and the exhibits, and I just wanted you to take a look at the way it's all framed and look at some of those exhibits. So here's just a couple of examples. You can see from the complaint, the plaintiff's works, defendant's works, this Kung Fu Panda bear with the hat, with the staff, right? Those kinds of details. Here's one of the characters that I think we saw in that original clip, right? These kind of bull-type characters with the club or sword or axe, and here's one from the defendant's game. And I think when you look at those, you can certainly see the resemblances between those. The question is going to be, are these sufficiently delineated? Are there other characters like this? I said Kung Fu Panda, right? The Disney movie Kung Fu Panda. Are there other sort of versions of the wise Kung Fu warrior that might be an animal like a panda? This kind of bull character, does this go all the way back to bull characters even in Greek mythology or other mythology? How does all that relate? Well, what happens in the opinion that you have is that the court dismisses the original complaint on a 12b6 motion, really because the court said, I don't think this complaint is pled with enough specificity, but the court gives leave to amend. An amended complaint is filed, and there's a subsequent motion to dismiss the amended complaint, which is decided without an opinion, and the court says, well, now it's been repled with enough specificity, allows the case to go forward, and the litigation is now pending. There were some discovery, I looked at the docket, there were some discovery disputes, there was some issue about potential alternative dispute resolution, but it's an ongoing litigation. So, there's an interesting example where perhaps you look at these characters and say, yeah, they're similar, but, I can identify characters in other kinds of literature and older literature that these are in many ways very similar to him. And I think this, the Minotaur is the creature I was thinking of from Greek mythology, is certainly what this is drawn from. It's even called Tauren, Minotaur, Tauren, Taurus the bull, right? It'll be interesting to see how that develops. But meanwhile, it's an ongoing litigation, which is expensive and which can be kind of difficult to get out of. So this is another area I think that is going to be sort of continually developing, this area of the copyrightability of video game characters, how those characters spill over into related media, like from console to PC games to handheld games to other properties like books and movies and television shows, and to a variety of other ways.